We'll talk about lawyers later on, but first let's talk about insurance companies. Should a victim in a personal injury matter talk with the insurance company adjuster at all, and should they sign any forms that they're given to sign?
Generally, we tell all of our clients not to talk to the insurance adjuster, and certainly not to sign any forms. One thing that people need to be aware of is that the insurance company adjuster is not your friend. He or she will try to act like they're your friend, and they will try to extract all the information they can get from you. They'll try to extract any kind of written documents that they can get to you. But the purpose of all of their calls and requests are to minimize your claim. In other words, they're not trying to help you by what they're doing. They're trying to hurt your case.
Well, what about writing the insurance company a reasonable letter? Wouldn't that get you some type of reasonable response or reasonable settlement?
Insurance companies are not in the business of reasonable. Insurance companies are in the business of maximum profit, and maximum profit for an insurance company occurs when they can charge as much as they can get away with charging, and that's very competitive, of course, for the insurance policy. And then on the other end is they pay the minimum that they can get away with paying on any claim. So what they do is they try to delay the claim, they try to minimize the claim, anything to pay less than they have to.
Well, now, one of the conceptions, or maybe it's a misconception, is that the insurance company has to pay your medical bills as they become due. Is that in fact the case, or if not, what is the situation?
No, the claim against the other party, the insurance company for the other party will not pay your medical bills as you incur them generally. They will make a settlement at the end of the case when all of your bills have been received. They've received medical reports from the doctors, and in other words, you'll get one lump sum payment. On the other side of the coin, there is insurance coverage that you buy for yourself under your own policy. It's called medical payments coverage, and that's first party coverage, which means that's a policy between you and your own insurance company. And those kinds of coverages, generally, they will pay you as you incur your bills because it's your own insurance company.
Well, and that's a good segue to the next question I had in mind, which is, what happens if your medical bills get paid by your own health insurance or perhaps by a government program like Medicare or Medicaid, and then you get a settlement from the insurance company that is insuring the person at fault? What happens there in that situation?
Well, it depends on whether or not a lien has been filed. Frequently, the governmental agency, Medicare, Medicaid, or Blue Cross Blue Shield health insurance carrier will send a notice that they have a lien for monies paid for the medical bills. Generally, it's going to be less than the full amount of the medical bills, and that will be repaid out of the settlement. But in Virginia, theoretically, medical bills can be paid multiple times. They can be paid by your health insurance carrier. They can be paid by, if you have medical payments coverage under your own policy, they can be paid there, and then they can also be paid under the other party's insurance policy. And the theory behind that is that the insurance company of the party that caused your injury should not benefit from your insurance coverage. In other words, you pay a premium for your medical payments coverage. There's no reason that the other party's insurance companies should benefit from that because they didn't pay any premium for that benefit. You paid the premium, so you're entitled to that benefit, and they shouldn't have the benefit of that.